So we can return to today's program. Today, we're very privileged to be hosting the 2025 Kaplan lecture, and we are honored to be in the presence of two legal giants and visionaries, Mr. Neil Kaplan, and we're also very grateful that we have the Chief Justice of Singapore, Sundaresh Menon, to be the speaker of this year's Kaplan lecture. I would also like to express our gratitude to King & Wood Mallesons for their generous sponsorship of tonight's event. So without further ado, I would like to invite Neil to say a few words. Neil, please.
Thank you, Joanne, and good evening, everybody. It's my very real pleasure to welcome you all to the 19th consecutive lecture in this series. It's wonderful to be back at HKIAC this year, and I thank the BD team for all the work they've done in arranging everything. I'm also very pleased to recognize and thank King & Wood Mallesons for returning as a sponsor for this lecture. As a firm, they are strong supporters and users of arbitration, and you will hear from Paul Starr a little later, who will add some words of his own. Tonight is yet another first. It will be the first time that we've had a sitting Chief Justice to give this lecture. We've had retired Chief Justices and retired Presidents of Supreme Courts, but I've never been able to prize a sitting Chief Justice from his court. And it's a great pleasure to have done that with Sundaresh Menon. It's not really surprising that Chief Justice Menon should be that judge, because he's always generous with his time, especially for events that focus on arbitration. Sundaresh was born in Singapore. He obtained his degrees from NUS in Singapore and Harvard, and was admitted as a solicitor in Singapore. He was a founding partner of the Wong Partnership in 1982, and he's also been a partner at Raja and Tarn and also at Jones Day, where I first met him by a video conference between London and Singapore. He was appointed Attorney General of Singapore in 2010 and became the first Singaporean-born Chief Justice in 2012. As Attorney General and Chief Justice, he's played a significant role in turning Singapore into the leading arbitral venue that it is today. As Chief Justice, he has overseen reforms of legal education, court processes, and professional ethics, to name but a few. He also set up the Singapore International Commercial Court. He's delivered some notable judgments on a wide variety of subjects, but relevantly for tonight, it's sufficient to say that his judgments on arbitration issues have provided very thoughtful and clear guidance on a number of issues, both domestic and international arbitration. But tonight, he tackles a topical and difficult subject, namely the role of arbitrators when corruption is suspected but not raised by the parties. My very real pleasure to invite Chief Justice Menon to deliver the 19th lecture in this series.
Professor Neil Kaplan, distinguished guests, ladies and gentlemen, a very good evening. Let me first offer the heartfelt condolences of my country, my judiciary, and myself to the people of Hong Kong and to the families and the loved ones of all the victims. We stand by you and we grieve with you and we hold you in our hearts and our prayers on the tragic loss of life occasioned by the fire. We also thank the many who have risen to show that the spirit of Hong Kong remains indomitable, even in the face of such a tragedy. And the fact that this event is proceeding at this time, I think, is a sign of that. Let me also take this opportunity to thank Neil for his very generous and kind introduction and for inviting me to deliver this lecture. It is a great honor. Since the inaugural lecture was delivered in 2007, the stage has been graced by many illustrious speakers, including a good friend to both Hong Kong and Singapore, the Right Honorable Lord Neuberger, who is with us this evening, the Honorable Yves Fortier, King's Counsel, and more recently, the former Chief Justice of Hong Kong, and my very dear friend, the Honorable Geoffrey Ma. That esteemed list reflects the standing and stature of the person in whose honor this lecture is given. Over the course of more than 5 decades, Neil has distinguished himself as a barrister, a judge, and perhaps most notably as one of the leading figures in the world of international arbitration. Indeed, such has been his contribution to the development and growth of arbitration in Hong Kong that he's widely regarded as the father of Hong Kong arbitration. So on behalf of all of us here tonight, thank you so much, Neil, for all that you have done. As you've heard from Neil, this evening I will be speaking about the challenge of corruption in international arbitration. This is a subject that has attracted much attention and debate, perhaps especially after the recent decision of Mr. Justice Robin Knowles in Nigeria against PNID. But it is by no means a recent concern. Indeed, when Yves Fortier spoke and delivered the Kaplan lecture of 2014, he spoke on this very subject, and he identified, and I quote, a manifest reticence on the part of arbitrators to act on evidence of corruption when it raises its ugly head. He observed that corruption in international arbitration is rarely outcome determinative, and also that positive findings of corruption in international arbitral decisions are very rare. In the intervening years, there has been a growing recognition that arbitrators can and should do more to address issues of corruption in arbitration. This is perhaps best reflected in the ongoing work of the ICC's task force addressing issues of corruption in international arbitration, which in November last year released, and I quote, detailed guidance on the identification and assessment of corruption in arbitration proceedings. This document I will refer to, and I refer to it as the red flags document. But despite this emerging consensus, many fundamental questions in this area continue to divide courts and commentators. I will focus this evening on 3 issues. First, what, if any, is the basis of a tribunal's authority to investigate corruption of its own motion? In the specific situation where there are sufficiently manifest indicators of corruption on the record, but where neither party has raised the issue. To be clear, this is the paradigm situation that I'm addressing, rather than cases where corruption has been pleaded and is therefore a live issue, or on the other hand, where there are no real indicators of corruption. Second, can and should arbitrators report suspicions of corruption to the public authorities? And third, what approach should supervisory courts take when reviewing cases involving corruption, bearing in mind considerations such as the principle of minimal curial intervention and finality of arbitral awards? My central thesis is that both arbitral tribunals and supervisory courts should adopt a more proactive and robust approach when dealing with issues of corruption in international arbitration, although this must be kept within principled and clearly defined limits. My address this evening will proceed in 3 parts with broad reference to the past, the present, and the future. To set the context for our discussion, I will first explore how the prevailing attitude to issues of corruption and how these should be dealt with in the context of international arbitration has changed and evolved over time. Next, I will address the 3 key issues that I've just outlined and suggest how they might potentially be addressed. Now, I should emphasize the disclaimer that these are extrajudicial reflections which might well change with the benefit of assistance as and when it arises in an appropriate case. And finally, I will highlight the vital need for all our jurisdictions to address these issues and more broadly matters of transnational commercial law with greater clarity, consistency, and coherence, focusing in particular on the role of the courts. I should also be clear that my primary focus today is on corruption in the underlying contract or arbitration agreement, as opposed to corruption in the arbitral process itself, such as when there is bribery of witnesses, counsel, or even tribunal members. And I say that because the latter category, where there's corruption in the arbitral process itself, provides well-established grounds for setting aside or refusing to enforce or otherwise invalidating awards, and has not generally given rise to some of the difficult conceptual questions that we are going to be concerned with. Let me begin with a historical perspective. For a long time, issues involving corruption were considered unsuitable for resolution through the arbitral process and were even deemed non-arbitrable. And several reasons have been advanced for this, but at its core, the underlying concern could be traced to a dissonance between the public dimensions of corruption and the very private nature or character of arbitration. On the one hand, arbitration is traditionally seen as a private method of dispute resolution that concerns only the rights and interests of the parties who have consented to the arbitral process. And it has even been referred to as the quintessential paradigm of private justice. Corruption, on the other hand, engages broader public interests, especially when public actors are involved, and it attracts criminal sanctions that may only be imposed by the courts. And so, as with other areas of law which engage the public interest, such as competition law, intellectual property law, and insolvency law, claims involving corruption were once considered to be non-arbitrable. As Gary Bourne observes, where the issue of bribery was raised previously in arbitrations, the response of tribunals was often to find a lack of jurisdiction over the issue. Additionally, there were also practical difficulties in adjudicating issues of corruption in the course of an arbitration. Tribunals, as private and consensual bodies, have limited powers to compel the production of evidence, in contrast to the enforcement powers of the state. And furthermore, for most cases, confidentiality is an important feature of the arbitral process. And this sits uncomfortably both with specific actions that a tribunal may wish to take, such as the reporting of criminal activity or suspected criminal activity to the authorities, and also with the general desire for transparency in combating corruption. But this traditional view has, over the last few decades, shifted and settled in favor of a widespread acceptance that issues of corruption are arbitrable, particularly when they arise in the context of whether or not they affect civil liability. I highlight two cases that illustrate this evolution. The first is the decision of the High Court of England and Wales in Westacre Investments, which was upheld on appeal. The defendants in an arbitration there sought to resist the enforcement of an arbitral award, contending that the tribunal lacked jurisdiction to determine the dispute because the claim arose from a consultancy agreement that had been entered into for corrupt purposes. At first instance, Justice Coleman rejected the submission, holding that even where an underlying contract is illegal at common law or under statute, the arbitration agreement ancillary to that contract may, depending on the nature of the illegality in question, remain capable of conferring jurisdiction on the arbitrators to determine whether the particular illegality presented renders the contract unenforceable. Insofar as corruption was concerned, he considered that the public policy of sustaining international arbitration awards on the facts of that case outweighed the public policy in discouraging international commercial corruption. The tribunal was therefore found to have jurisdiction to determine whether the contract was illegal, and the court would not reopen the tribunal's finding that it was not illegal unless the tribunal had ignored palpable and indisputable illegality. I will return to that point, just keep it in mind. I'll return to that point about what standard courts should adopt in looking at this later when I consider the role of the supervisory courts. To similar effect is the decision of the US District Court for the Southern District of New York in Development Bank of the Philippines against Chemtex Fibers, where the plaintiff brought claims under the Racketeer Influence and Corrupt Organizations or RICO statute. Departing from the traditional position that claims under the RICO Act were not arbitrable, the court held that the parties' agreement to arbitrate ought to be enforced due to concerns of international comity, respect for the capacities of foreign and international tribunals, and sensitivity to the needs of the international commercial system for predictability in the resolution of disputes. What explains this shift? If we were to take a step back, the question of arbitrability is fundamentally a question of public policy. As the Singapore Court of Appeal reiterated in Anupam Mittal, the essential criterion of non-arbitrability is whether the subject matter of the dispute is of such a nature as to make it contrary to public policy for that dispute to be resolved by arbitration. But public policy is not static or immutable. Over the past decades, arbitration has grown tremendously in popularity and is now overwhelmingly the preferred method for resolving cross-border commercial disputes. In addition, given the size and scale of many of the contracts and the related claims that are resolved in arbitration, an inability on the part of tribunals to consider questions of corruption seems to significantly undermine the effectiveness and the attractiveness of arbitration. Taken together with other considerations such as the desirability of avoiding the fragmentation of disputes where possible, and the growing acceptance of the competence and capabilities of arbitral tribunals to determine issues of corruption where these have a bearing on civil liability, these developments have collectively strengthened the public policy in favor of the enforcement of arbitration agreements, even where issues of corruption are raised. And at the same time, there have been some developments in the arbitration landscape that may help mitigate some of the practical difficulties that I've outlined, such that arbitrators today may be somewhat better equipped to deal with issues of corruption. These developments include the ability to issue subpoenas and the possibility of having recourse to the seat court to compel witness testimony in the production of documents. Now, to be clear, these powers are not universally applicable in all jurisdictions, nor do they replicate the coercive powers of national courts or enforcement agencies. But they do offer some useful tools for tribunals to manage what can obviously be a delicate inquiry into matters on which the parties, for obvious reasons, might not be forthcoming. While the current broad consensus on the arbitrability of issues of corruption is to be welcomed, there remain some fundamental questions of practical importance that are still contested, and it is to these that I now turn. The first and foundational question is whether there is any basis at all for a tribunal to investigate corruption on its own motion. It is now largely uncontroversial that a tribunal can and indeed must determine even questions of corruption where these have been raised by the parties for determination. But where the parties have not alleged corruption or, going further, have even expressly agreed that the tribunal should not look at it, can the tribunal nonetheless do so? On one view, such a step might amount to the tribunal acting in excess of its jurisdiction, potentially giving rise to a challenge against the award. I suggest, however, that the better view is that the tribunal can and indeed should investigate further when it has good reason to suspect that corruption might affect the relief sought. And I say this for a couple of reasons. First of all, this, I say, would be part and parcel of the tribunal's core mandate to address issues that would affect the validity of the claim before it, and this would include issues of illegality, public policy, or mandatory law. If evidence of illegality emerges over the course of the hearing that could have a bearing on the liability of a party or the relief sought, then far from overstepping its prescribed boundaries, the tribunal might be said to have failed to properly determine the dispute submitted to it if it didn't address those issues. This understanding of the tribunal's role, I suggest, is reinforced by the tribunal's duty to strive to render an enforceable award, a duty that is enshrined in most major institutional rules, including those of the HKIAC and the SIAC. It should be noted that it is well established that both the seat court and the enforcement court are generally able to review issues of international public policy on their own motion. We see this power reflected in instruments such as the model law and the New York Convention. Broadly, the concept of international public policy refers to a state's most fundamental values, which must not be breached even in cases that have little or no actual connection to the jurisdiction. It is relatively uncontroversial that corruption would fall within the scope of international public policy. Therefore, if there are sufficient manifest red flags suggesting corruption, then even if the parties do not raise the issue or are reluctant to address it, a tribunal, I suggest, would be remiss to ignore it, given that this might result in what might prove ultimately to be an unenforceable award. The World Duty Free case illustrates the dangers when indicators of corruption are not properly investigated in the arbitral process. The dispute began when World Duty Free commenced an ICSID arbitration against Kenya for breaches of a lease agreement. The tribunal rejected the claim, finding that the lease agreement had been obtained by a $2 million bribe paid to the former president of Kenya, and held that it would therefore violate public policy to enforce the agreement. Undeterred, World Duty Free then commenced a second arbitration before an ad hoc tribunal under the same tainted lease agreement, but against a different defendant, the Kenyan Airports Authority. And there it succeeded in obtaining an award for about $50 million in the second arbitration. But that was set aside by the Kenyan High Court on the ground of public policy. Neither party had raised the issue of corruption in the second arbitration. Nonetheless, the court held that once the ICSID award was brought to the second tribunal's attention, it should have paused and interrogated the matter before issuing an award that ran contrary to public policy. Another reason in support of the tribunal's authority to investigate corruption of its own motion is to prevent itself from being used as an instrument of fraud itself. Arbitrators are private adjudicators, but I suggest they're also an integral part of the international legal framework that is in place for resolving cross-border commercial disputes. And this is a concept that I've referred to as the transnational system of commercial justice. I would go so far as to say that because of the fact that the overwhelming majority of cross-border commercial disputes today are resolved precisely in arbitration, it is a fundamental part of that transnational system, which is supported by widely subscribed instruments such as the New York Convention and the model law. Within this system, I suggest there is a public dimension to the role of an arbitrator who presides over quasi-judicial proceedings and who is empowered to issue binding decisions which may be enforced as if they were judgments issued by courts. That role must be carried out in a way that strengthens rather than subverts arbitration's legitimacy and standing within the broader rules-based international order. The reasoning of the Singapore International Commercial Court in Lau Holdings captures this point aptly. During the arbitrations, the defendants sought to admit newly discovered evidence of bribery, corruption, and fraud. And this was in spite of an agreement between the parties not to admit any further evidence after a certain point in time. And as I will make the point later, it has to be noted, this was not an agreement that was designed to shield scrutiny. It was just an agreement that the parties had entered into. But the tribunals read into the parties' agreement an exception for compelling circumstances and allowed the fresh evidence to be adduced. The plaintiffs then sought to set aside the awards in the SICC, arguing, among other things, that the tribunal's decision to admit the new evidence contravened the parties' agreed procedure. The SICC rejected this argument and stated that the parties could not, by a prior agreement, prevent a tribunal from reviewing evidence of corruption. Otherwise, and I'm quoting from the judgment, parties could enter into procedural agreements deliberately or unintentionally, precluding evidence of corruption, and arbitral awards, tribunals might make awards supporting or enforcing that corruption. The SICC observed that, as with national courts, arbitral tribunals have a public duty to consider corruption. And this duty arises not only when the tribunal has to deal with allegations of corruption raised by the parties, but more generally where it is faced with evidence of possible corruption. It seems to me that because of the public dimension of arbitration, which stems from its role as an integral part of the transnational system for the administration of commercial justice, even the agreement of the parties cannot be allowed to shield from scrutiny matters that offend international public policy, such as fraud or corruption. But I accept there are limits to this. Tribunals are not and should not be expected to proactively investigate the possibility of corruption in every case. That would clearly go too far. I would respectfully suggest that there are at least two preconditions that must be satisfied. The first is relevance. The suspected illegality must have a bearing on the validity of the claims in dispute, because ultimately the central role of the tribunal is to resolve the dispute submitted to it and not to be an international policeman or an international prosecution agency looking out for any possible wrongdoing. As explained earlier, some of the justifications for the tribunal's authority to investigate corruption is that any potential illegality may invalidate the claim or render the award unenforceable. By the same token, I suggest the tribunal risks acting in excess of jurisdiction if it pursues a line of inquiry into corruption that is unrelated to the dispute. And the second precondition I suggest is that there should be sufficiently manifest indications of corruption or red flags on the face of the record. I think this is important because it would greatly diminish the efficacy and efficiency of arbitration if tribunals were to pursue investigations where there was no real basis for harboring even a reasonable suspicion of corruption. For the same reason, a tribunal's approach need not be a binary one, treating the threshold of suspicion as one that is either crossed or not crossed. Rather, I suggest that the tribunal's response can be proportionate to the nature of the issue it is faced with. The more concerning the nature and extent of the indicators of corruption, the more rigorous might be the inquiries that the tribunal might consider undertaking. As to what should put the tribunal on alert, the red flags document that I referred to provides valuable guidance. The document distinguishes, for instance, between general and specific red flags. General red flags relate to concerns about the general climate of corruption in a country or industry, whereas the specific concerns relate to indicators such as a party's history of corruption-related prosecutions or convictions, the involvement of public officials in selecting or recommending business opportunities, opaque corporate structures such as shell companies in offshore havens, and a party's lack of qualifications for performing the services it offers. As the ICC's task force recognizes, general red flags alone would generally be unlikely to trigger further examination by a tribunal, but specific red flags will likely carry greater weight in this context. This brings me to the question of how tribunals could respond once they're put on notice by red flags in the proceedings. While paying attention to the need for a proportionate, contextual, and flexible approach, I suggest it is helpful to think of the inquiry as one that comprises broadly escalating stages, with various procedural and evidentiary tools that may be deployed at each stage. The inquiry might begin simply with the tribunal inviting explanations for apparent irregularities. Seemingly suspicious circumstances could have legitimate explanations that counsel can readily provide without having to call for additional documents or witnesses. Where further evidence is thought to be required, the tribunal might consider inviting the parties to adduce such evidence and give the appropriate directions. Many institutional rules confer on tribunals the power to conduct necessary inquiries into issues not directly raised by the parties and to order the production of documents or testimony that the tribunal considers relevant. If necessary, such as if the party is not forthcoming or insists on a formal subpoena, a tribunal could request the assistance from a seat court in taking evidence under the relevant arbitration laws. In Singapore, for instance, courts may issue orders to compel witnesses to give evidence before a tribunal or produce documents. And if evidence is still not forthcoming, a tribunal may, in appropriate cases, draw adverse inferences from a party's failure to produce the relevant evidence requested by the tribunal. Because corrupt activity is by its nature concealed, and because there are limits on a tribunal's ability to compel parties to comply with production requests, the appropriate use of adverse inferences can be critical in arriving at a finding of corruption. And the prospect of such inferences can provide a powerful incentive for the parties to try to address the tribunal's requests and concerns at the appropriate juncture. Now, of course, before a tribunal makes any inferences or findings, it's got to give the parties clear warning and an opportunity to respond, lest it finds itself at the wrong end of a natural justice challenge. I would like to refer briefly to the case of Metal Tech and Uzbekistan that offers a useful example of the approach that tribunals could adopt. There, although the respondent raised allegations of corruption, it did not initially adduce sufficient evidence. The tribunal's suspicions were triggered when facts concerning the payment of substantial sums emerged in the course of the hearings. The tribunal responded by making further inquiries about the reasons for such payment and giving the claimants the opportunity to substantiate the reality and legitimacy of the services it was said to have been paid for. When the claimant failed to do so, the tribunal inferred that, in fact, no legitimate services had been provided and ultimately dismissed the claims. Greater difficulties may arise where corruption seems apparent on the face of the record, but the parties together refuse to cooperate in addressing the tribunal's inquiries or even instruct the tribunal not to consider the issue on the basis that the parties have agreed that there is no question of corruption. There are two potential obstacles in such a case. The first concerns the tribunal's jurisdiction. It might be argued that the tribunal has no jurisdiction to go behind the parties' agreed understanding that there was no corruption, given the tribunal derives its jurisdiction from the agreement of the parties. However, as I have suggested, this line of reasoning may not apply to issues of corruption if we accept that there is a higher public policy at stake. Otherwise, it could give rise to an untenable situation where the parties could simply agree that there was no corruption, despite sufficiently manifest indicators to the contrary, and effectively use the arbitration process to launder their obligations under a corrupt contract into an internationally recognized award. As I mentioned in Lao Holdings, the parties did have a procedural agreement to exclude further evidence, though not, it seems, to prevent scrutiny of possible corruption. And the court held this could not limit the tribunal's authority to look into evidence of corruption. The second potential difficulty concerns issues of waiver or abuse of process. It might be argued that a party who initially disclaimed corruption during the arbitration should not be permitted to raise it before the courts at the post-award stage. But again, as I've mentioned, the public policy ground is of a fundamentally different character from the other grounds of challenge, in that the courts are generally able to review issues of public policy on their own motion, regardless of whether the parties have raised them. Thus, even if it could notionally amount to an abuse for the party to raise corruption belatedly, the court might nonetheless take the point on its own motion. This does not mean that such tactical behavior should go without consequences. Courts could consider, for instance, imposing cost consequences to deter tactical hedging from parties who strategically withhold corruption allegations until the post-award stage. Let me then return to Nigeria and PNID, which provides a useful case study for discussion. The case concerned a gas supply and processing agreement between a BVI company known as Process and Industrial Developments Limited, or PNID, and the federal government of Nigeria. Under this agreement, Nigeria was to supply wet gas to processing facilities constructed by PNID. Keep that in mind. The concept was Nigeria provides gas for a process facility that was to be constructed by PNID. Neither side performed any of this. PNID then commenced arbitration against Nigeria and obtained a final award of around 6.6 billion US dollars, which by any means, any measure, is a staggering sum. Given that PNID had failed to construct any gas processing facilities. After the final award was issued against Nigeria, Nigeria obtained discovery against PNID in various courts around the world, and armed with the new evidence, it sought to set aside the award on liability and the final award before the English Commercial Court. And it alleged that PNID had engaged in corruption, bribery, and perjury in both the underlying agreement and during the arbitration itself. Following a trial that lasted over 8 weeks, Mr. Justice Knowles found that PNID had presented false evidence by concealing the bribes it had paid in connection with the underlying agreement, that it had continued to make corrupt payments during the arbitral process, and had improperly retained Nigeria's privileged legal documents. The arbitral awards were therefore set aside on the basis that they'd been obtained by fraud and were contrary to public policy. Although the awards were set aside on these specific grounds, Mr. Justice Knowles made some broader observations on the approach of the tribunal, which he described as very traditional. In particular, he questioned whether the tribunal was, quote, stuck with what the parties did or did not appear to bring forward, and whether it could and should have been more direct and interventionist. That's precisely the question we are considering today. If we were to consider the ICC's red flags document, we would find that many of the red flags mentioned there appear to have been present in the case. Let me highlight 3. First, the agreement was on its face, as Justice Knowles said, deeply suspicious and remarkably lacking in detail. In his words, the 20-page agreement better described the description of an outline rather than a fully developed contract for a 20-year, multi-billion-dollar project. Second, the agreement was framed, as he put it, in catastrophic terms for Nigeria. Nigeria had an essentially unqualified obligation to deliver gas for processing, and that was not conditional upon PNID's obligation to construct the necessary gas processing facilities. And third, Nigeria had entered into the agreement with a BVI company that had no apparent assets, no obvious industry experience, and no other credentials to suggest that it would be suitable to operate such a sophisticated arrangements. Under these circumstances, it seems to me there was a very reasonable basis for thinking that the tribunal in Nigeria and PNID ought to have investigated whether there was corruption in the underlying agreement that might have invalidated the claim. The two preconditions I've suggested, relevance and the presence of sufficiently manifest indicators of corruption, appear to have been satisfied. And I think it is fair to say that a more proactive and robust approach could and probably should have been adopted in line with what I have proposed this evening. That brings me to a related question, which is of considerable practical importance, and that concerns whether a tribunal has the duty or the power to report suspicions of corruption to the relevant authorities, or whether their duty of confidentiality would prevent their doing so. Most leading institutional rules explicitly acknowledge that confidentiality obligations are subject to overriding legal considerations. They typically provide that confidentiality is subject to compliance with the provisions of the laws of any jurisdiction or disclosure to authorities which a party is obliged by law to make. These rules recognize that the duty of confidentiality is not absolute and is overridden by mandatory legal obligations. But not all jurisdictions impose a duty or obligation to report corruption or suspected corruption. Let me first touch on the position in Singapore, which has been described as somewhat unique. There are two provisions that impose duties to report criminal conduct. First, Section 424 of the Criminal Procedure Code requires every person aware of the commission of certain offenses, including certain corruption offenses, to inform the police. Second, Section 45 of the Corruption, Drug Trafficking, and Other Serious Crimes Confiscation of Benefits Act, or what I refer to as the CDSA, imposes a duty to report on a person who, in the course of the person's trade, profession, business, or employment, knows or has reasonable grounds to suspect that property was used in connection with any act which may constitute criminal conduct. And this includes, obviously, the offense of corruption. Both provisions provide for the defense of a reasonable excuse, although whether arbitrators can avail themselves of this defense might be said to be untested. In the case of Section 45 of the CDSA, Singapore has provided for the particular position of arbitrators by introducing an amendment in 2014. This stipulates, first, that it will not be an offense for an arbitrator to fail to disclose any information or other matter which came to the arbitrator's attention in the course of any arbitral proceedings in which the arbitrator acted as an arbitrator. In other words, there's no obligation. But the amendments don't stop there. Section 45(7) provides that where a person does make the relevant disclosure in good faith, that disclosure is not to be treated as a breach of any discretion upon the disclosure imposed by law, contract, or rules of professional conduct, and the person shall not be liable for any loss arising out of the disclosure or any act or omission in consequence of the disclosure. In short, the position in Singapore has been described as placing the onus on the arbitrator to decide whether or not to report, while conferring statutory protections both ways, whichever way they decide they are protected. So in jurisdictions like Singapore, which place this discretion in the hands of the arbitrator, what should guide their decision? I suggest that in general, arbitrators ought to report corruption or suspected corruption to the relevant authorities. I'm not saying they have a duty or an obligation to do so, I am saying that they clearly have the power to do so, and I am suggesting that they should exercise that power to report corrupt activity where it is not prohibited by the applicable laws or rules. And I say this because, as a matter of first principle, the obligation of confidentiality exists to afford the parties a private mode of dispute resolution, surely for legitimate goals. The protection does not exist to shield corruption or other forms of illegal activity. And further, while confidentiality is undoubtedly regarded as one of arbitration's core attractions, I don't think it is to be seen as a defining or immutable feature. It's not addressed in the major international conventions, nor is it provided for in the domestic legislation of many jurisdictions. Indeed, it has been observed that the position in New York and indeed the US is generally understood to be that there's no inherent duty of confidentiality unless the parties contract for it. In Singapore and the UK, the obligation of confidentiality applies to all arbitration agreements unless the parties agree otherwise. But its precise contours and outer limits is governed by the common law. And although there doesn't appear to be any case law from the major jurisdictions that deals squarely with this issue, the decision of the Singapore High Court in AAY against AAZ provides some useful guidance. There, a party to the arbitration disclosed the partial award and other documents to the Commercial Affairs Department of the Singapore Police Force alleging fraud and conspiracy. The High Court held that disclosure to the appropriate authorities where there is a reasonable suspicion of criminal conduct is an exception to the obligation of confidentiality, which can be broadly categorized as falling within the public interest, though this is not to say that there exists or should exist a general public interest exception. Significantly, the court considered that confidentiality is a lesser interest than the public interest of having criminal wrongdoing revealed to the relevant authorities for their investigation. Now, AAY and AAZ dealt with disclosure by a party rather than by a tribunal, but I don't think that's material. The focus of the analysis should be on the public interest served by the disclosure and the function of the public body to which the information is disclosed, rather than by the identity of the disclosing party. If anything, tribunals may be in a better position than the parties to make such disclosures, since they are independent and impartial, and they have a professional obligation to supervise and uphold the integrity of the arbitral process. But we must recognize that addressing this issue effectively requires a multi-stakeholder approach involving tribunals, courts, legislatures, and arbitral institutions. Both courts and legislatures should provide the necessary supporting framework to encourage appropriate disclosure. This might involve making clear that the reporting of suspected corruption constitutes a recognized exception to the tribunal's confidentiality obligations and introducing statutory protections that immunize tribunals from potential claims or complaints arising from good faith disclosures. The Singapore model that I've just discussed might provide a useful template. Second, I think arbitral institutions should consider whether such exceptions can and should be spelled out in their own institutional rules. This would provide greater clarity and certainty for all participants in the arbitral process, whilst ensuring that the public interest in combating corruption is not compromised by overly rigid interpretations of the confidentiality obligations. Ultimately, the goal must be to create a framework that promotes the autonomy of parties to have their disputes heard in private, while ensuring that the arbitral system does not become a haven for those seeking to shield corrupt conduct from appropriate scrutiny. In achieving this balance, we serve not only the public interest in combating corruption, but also that of safeguarding the long-term legitimacy and sustainability of international arbitration. I turn to the role of supervisory courts in addressing corruption at the post-award stage. And this does present us with some competing tensions, and I will give you a sneak preview I'm not ultimately going to resolve those competing tensions this evening. But those tensions are the vital need to uphold the finality of the arbitral process and the principle of minimal curial intervention on the one hand, and the duty of the court to safeguard matters which are fundamental to the public policy of the state on the other. Let me outline the various situations that might arise at the post-award stage. The first concerns cases where corruption infects the arbitral process itself. And as I mentioned at the outset, it is uncontroversial that the courts have both the jurisdiction and indeed the duty to intervene in such cases. And Nigeria and PNID is perhaps the best known recent example of this category, in that at least part of the complaint pertained to corruption in the course of the arbitration itself. The second and more complex situation arises where corruption infects the underlying contract or the arbitration agreement. And in that category, a further subdivision emerges between cases where the issue has been considered by the tribunal and those where the issue has not been considered. And they both give rise to different problems. Where the tribunal has not considered the issue of corruption, the courts, I say, can nonetheless consider the issue on the basis that the award may conflict with the public policy of the state. And as I've already covered, I won't go through that again. Concerns of abuse of process or waiver can be trumped by the response that the public policy of the state is impugned. But where the tribunal has considered the issue of corruption and the court is then asked to review that finding, there is a profound tension between the competing imperatives that I have outlined. And it is to this situation that I think we find considerable divergence in judicial approaches. I have broadly categorized the approaches to three groups: minimal review, maximal review, and contextual review. And each of them represents a different calibration of these two competing interests. The minimal review approach, it prevails in most major common law jurisdictions, including England and Wales, Hong Kong, and Singapore. And under this approach, the findings of the tribunal are upheld as a starting point, with the courts intervening only in exceptional circumstances. And there are at least 4 situations which have been recognized in the case law as being sufficiently exceptional. First, where there is palpable and indisputable illegality on the face of the award. That's a very high standard. Second, where there is new and cogent evidence that has surfaced which could not reasonably have been produced before the tribunal. That's really a situation where the tribunal has not really considered the issue. Third, where the impugned error relates to an error of law concerning what the public policy of the state is, as opposed to an error of fact. And finally, where the tribunal's decision-making process was tainted with fraud, a breach of natural justice, or other vitiating factor. And I think, to me, this last category is better conceptualized as a generic challenge against the award on orthodox grounds rather than specifically resting on public policy. At the other end of the spectrum lies the maximal review approach, which basically contemplates a fresh de novo review of findings on matters of public policy. Under this approach, the courts are neither limited to the evidence submitted to the tribunal, nor bound in any way by the findings or the tribunal's assessment of the evidence. And this represents the current approach of the French courts, as exemplified in the recent decision in Belacon against Kyrgyzstan, where the Court of Cassation set aside an award because it disagreed with the tribunal's finding that allegations of money laundering were not made out. The court held that its inquiry into corruption was neither limited to the evidence produced before the tribunal, nor was it bound by those findings, assessments, or qualifications of the tribunal. And the third approach is that of contextual review, which represents a sort of a middle ground, is intended to represent a sort of a middle ground between the two approaches. And while this doesn't represent the law in any of the major jurisdictions, it was outlined or formulated by Lord Justice Waller and Soleimani and later developed in his dissenting judgment in Westacre. And this proceeds in 3 stages. The first is the court must be satisfied there is prima facie evidence of illegality. Second, it will then conduct a preliminary inquiry and determine whether to give full faith and credit to the award, considering factors such as the strength of the contrary evidence, the competence of the tribunal, and the evidence of collusion or bad faith in the procurement of the award. And finally, if satisfied that the award is potentially unsafe, it will then undertake a more elaborate inquiry on the issue of illegality. So what should be the approach? I think there are shortcomings with each of these approaches. A maximal review, such as is applied in France, I think is too broad because it doesn't accord any weight to the principles of finality and limited curial intervention, minimal curial intervention. And the case for a maximal approach seems to be significantly reduced if tribunals were to take a more proactive approach to issues of corruption, as I've suggested. On the other hand, a minimal approach may set the bar too low, and it could even encourage unscrupulous parties to use the arbitral and judicial process to mask and whitewash corrupt schemes. And if a middle ground is to be preferred, it may seem logical to consider the contextual review, but as others have observed, this appears to be too subjective, uncertain, and unworkable in practice. It is not entirely clear how one should delineate the different stages of the inquiry, and there's a real possibility that the court embarks on a full-scale review at the outset. An alternative might be for the courts to engage in a limited rather than a de novo review of the tribunal's findings, where it looks at the findings on corruption, but only if satisfied that the issue implicates the public policy of the forum. And this has been formulated by two Singapore lawyers, Professor Darius Chan and Mr. Elias Kong, as a two-stage approach. At the first stage, the court doesn't look at the evidence, but considers whether the allegations or the suspicion, if proven, would engage the public policy of the forum. And it really functions as a sieving process where the court is concerned with the severity of the alleged illegality and whether the public policy of the forum is impacted by that allegation if made out. If the court finds that the public policy of its jurisdiction is implicated, it then proceeds to undertake a limited review, which would differ from a full de novo hearing in at least two ways. It'll be based on the evidence that is available on the record, and the court should not admit new evidence unless it was not reasonably available at the time of the arbitration. And secondly, the court should only review the award to the extent it is necessary to decide the specific allegations implicating the public policy without allowing the parties to reopen the entire award. That's as much as I'm going to say. Those are the options on the table. It's a complex area of the law that doesn't admit of easy answers and where there are a diverse range of viewpoints. And because it may be ripe for consideration by the courts, I should wait for it to come up before the courts. I want to turn very briefly to the final part of my lecture. This evening, I've outlined several areas where some uncertainty as well as divergences exist both in philosophy and approach, whether on the part of tribunals or on the part of supervisory courts. And this reflects a more fundamental challenge that I want us to think about, which extends beyond the subject of corruption and arbitration, and that is the importance of striving for greater clarity, coherence, and consistency generally in matters of transnational commercial law. And it is, as I've said earlier today, it's something that relates to something I'm very passionate about, that I've spoken about many times, the importance of us thinking in terms of a transnational system of commercial justice. It seems to me to be clear that as far as possible, convergence is not just desirable, but it's even becoming necessary. And I advance four reasons. First, legal differences inevitably increase transaction costs, undermine predictability and efficiency that commercial parties need in matters of commerce. Second, these uncertainties can incentivize forum shopping. Parties engaged in corrupt activity may be tempted to structure their arbitrations or enforcement strategies around jurisdictions that are perceived to be less robust in addressing these issues. Third, we should strive for coordinated responses that represent the most effective solutions to address global challenges such as corruption. Coordinated responses instill trust and confidence in both the integrity of arbitration and, more importantly, in the rule of law. And fourth, legal differences, I think, place arbitrators in an invidious position of not knowing which approach to take, particularly when the seat court's approach might deviate from that of possible enforcement jurisdictions. Apart from the need to promote convergence, we should also appreciate the vital role that supervisory courts have in protecting and enhancing the legitimacy of arbitration, both by establishing and reinforcing rule of law norms, as well as by setting and upholding baseline standards. It has taken an enormous effort to move beyond viewing the relationship between courts and arbitration as one of mere oversight or grudging accommodation. It is time for all of us to embrace a more collaborative partnership that recognizes the essential role that supervisory courts play in helping the arbitration ecosystem to develop and flourish. Pulling these threads together, supervisory courts should strive towards greater clarity, consistency, and coherence, both in how corruption is addressed in arbitration, but in matters of commercial law generally. And we might go about this thinking about a couple of angles. The first and obvious one is in enforcing and in enhancing international judicial dialogue, especially between key commercial courts that serve as important supervisory jurisdictions. This has historically occurred through the publication of written judgments and the cross-citation of authorities, which enables the gradual development of shared principles and approaches across jurisdictions. But more recently, we have seen a significant increase in direct communications and collaborations between courts through a wide variety of fora. The Singapore judiciary, for instance, co-hosts the Judicial Seminar on Commercial Litigation with the Hong Kong judiciary and the Supreme Court of New South Wales. Both our jurisdictions, Singapore and Hong Kong, also participate in fora such as the Standing International Forum of Commercial Courts and the Asia-Pacific Judicial Colloquium. These direct exchanges are greatly valued because they enable judges to share experiences and discuss emerging challenges in a safe setting. They also help in advancing convergence on the common legal issues we all face by promoting our understanding of the divergences. A second pathway of more recent vintage involves international courts. And I want to keep my brief remarks on the SICC and the newly opened Bahrain International Commercial Court, which was launched last month. The very structure and makeup of these international courts serve to promote convergence and consistency. They facilitate the cross-pollination of legal ideas not only through the diversity and strength of the international benches, which hail from a range of common and civil law jurisdictions, but also through their more open approach to foreign legal representation. These ideas are then evaluated in published written judgments that contribute to the body of transnational commercial law and which may be cited before other courts. A notable feature of the BICC is that appeals from the BICC may, at the option of the parties, be heard by the newly constituted International Committee of the SICC. The International Committee is jurisdictionally neutral and may in time hear appeals from other prescribed jurisdictions. Its bench comprises judges from the Supreme Court of Singapore, international judges of the SICC, and ad hoc judges from the jurisdiction that refers the appeal. And we hope that in time, the International Committee will serve not only as a robust mechanism for error correction, but will also promote clear, consistent, and coherent jurisprudence on important issues of commercial law, potentially including those that we've discussed today. While this might represent the present high watermark in terms of the efforts of commercial courts to develop a more coherent transnational system of commercial justice to support transnational commercial transactions, I suggest we are witnessing the growing influence of these courts of special design and purpose, and that they will have a significant influence in the time to come. Allow me to conclude. I have suggested today that we should adopt a more proactive and robust approach to dealing with issues of corruption in international arbitration, and I've sought to advance 4 key propositions. First, arbitral tribunals must recognize the authority and responsibility to investigate corruption when there are sufficiently manifest red flags, even if the parties choose not to raise the issue. Second, tribunals should be empowered and encouraged to report suspected corruption to the relevant authorities with the appropriate protections to shield them from potential liability. Third, supervisory courts should adopt a standard of review of awards that is neither so deferential as to encourage the laundering of corrupt schemes through arbitration, nor so intrusive as to undermine arbitration's finality and efficacy. And finally, at a broader level, we must all embrace the need to develop coordinated and convergent responses across jurisdictions. Ultimately, the challenge of corruption is one that must be adequately addressed if we are to maintain trust and confidence in the institution of arbitration and indeed in the entire system of transnational commercial justice. If we fail to act decisively, we risk not only the individual awards being tainted, but also the erosion of integrity and legitimacy of international arbitration. Thank you all very much for your attention this evening. It's been a great privilege and a real pleasure to address you. Thank you.
Well, Sundaresh, thank you very much. That was a fascinating lecture. I think that'll be a seminal lecture on this topic for future discussion. Thank you very much for all the work you put into it. It is rather late in the day, so unless anyone's got any really burning questions, I will ask Paul Starr to give a vote of thanks to our speaker. Thank you.
Well, first of all, thank you for a very thought-provoking, topical Kaplan lecture. Not everyone in the room will know that you used to be a construction solicitor. But due to the somber occasion, I cannot tell the story of how you and I settled a huge dispute. We avoided arbitration over a very large building on your beautiful waterfront in Singapore. You'll have to come back to hear the story another time. But I do want to echo what Neil was summarizing in your many achievements. Obviously, the SICC, you've mentioned yourself, the Convention on Mediation in Singapore, and what you're saying more recently about AI and taking great care over how we deal with generative, self-generating AI. But as a practitioner, I think most important of all has been the contribution your court has made to the general development of the common law around the common law Commonwealth. Now, when I started 40 years ago, I don't remember citing Singapore cases. And you may say, well, that's because that was, pre-1997. We had English law to cite. But since 1997, I don't remember an awful lot of citations until you became Chief Justice yourself. And whether it's dealing with crypto assets, whether crypto assets are property, whether it's in the field of arbitration, as Neil has mentioned, or dear to my heart, the Annan decision, which we upheld in the case of Shandong Chenming here in Hong Kong, to which I owe you a great personal debt. Your court has been cutting edge in really very thought-provoking decisions that we are now using here in Hong Kong and elsewhere. And that brings me to this Kaplan lecture, because certainly you've given us an awful lot of food for thought. In my perception is that fraudsters are now getting more and more sophisticated in the way they set up contracts with arbitration clauses. They even come to the arbitrations themselves. And the parties are bamboozled by that and very often don't raise the issue of corruption, certainly as fully as they might otherwise do. So I think we all need to go away and really think about the consequences of what you have just said to all of us when we're dealing with the sad increasing onslaught of fraud in this world. So on behalf of everybody, I'd like to thank you, and may we thank the Chief Justice again in the customary way. Thank you.